The only people who don't want to disclose the truth are people with something to hide.
I'm going to, reserve my last 2 minutes if I can for...
You have minus 2 minutes.
I'm already past it. Sorry. My apologies. Thank you, Your Honor.
We'll hear from the Secretary.
May it please the Court, Alexandra Robert Gordon from the Office of the California Attorney General for Appellee, Secretary of State Deborah Bowen. So just to remind the Court of the procedural posture of this case, this is an appeal from a dismissal of plaintiff's complaint with prejudice. So there are really only two questions before the Court. Did plaintiffs meet their pleading burden? Does the complaint state claims for relief under the First and 14th Amendments, the Equal Protection Clause, or the 20th Amendment? And two, could plaintiffs state claims under these provisions as a matter of law? And since the answer to both of these questions is no, the district court should be affirmed. Just to sort of touch briefly on some of the things that counsel has said, as the Court has noted, it is undisputed that at the time that she was running in 2010, Ms. Lindsay was 27 years old, and a person under the U.S. Constitution has to be 35 to be President of the United States. Although plaintiffs maintain that the Secretary of State does not have the authority to exclude Ms. Lindsay from the ballot, that's wrong as a matter of law.
As a matter of state or federal law?
Actually, as a matter of both, Your Honor. The Supreme Court has made it clear in cases such as Storer versus Brown, for example, that state election officials, and the Secretary of State is the chief elections official of the state of California, and under the government code, she has the power to make sure that all of the state election laws, as well as the federal election laws, are enforced. States maintain a lot of discretion over elections generally in the U.S. Constitution and over the ballot, and the Supreme Court has made it clear that a state official certainly can protect the integrity of the electoral process by not clogging the ballot with frivolous candidacies.
Well, suppose you had a Secretary of State that was part of the birther movement and declined to let Barack Obama on the ballot. What then?
Well, Your Honor, that's a different question.
Why?
And why is it a different question? Because I think we can all agree that whether or not President Obama is a U.S. citizen is very much in dispute. There's no dispute here that Ms. Lindsay is 27 years old. And so what the courts have said in the cases that plaintiffs have cited, Keyes and Robinson, is that the Secretary of State has they've said two things. One, the Secretary of State has no ministerial duty to investigate the qualifications. So in all these cases where they're alleging that President Obama or Senator McCain is not a U.S. citizen and the Secretary of State should get verification or he's using a forged birth certificate, the Secretary of State has no ministerial duty to investigate, and it is, in fact, committed to Congress to resolve disputes about a candidate's qualifications. However, it's a stretch to say that the Constitution gives to Congress the sole ability to resolve disputes about qualifications and then say that, for example, if a party wanted to run a dog on the ballot, that would go to Congress, that a state election official couldn't say, my goodness, this is not a human, or this party would like to put an inanimate object on the ballot.
Well, opposing counsel suggests that she might qualify as President-elect. What's your response to his argument?
My response to that argument is that I suppose she could qualify as President-elect until such time, I guess, as someone made an objection, found out she wasn't qualified, and then she's not qualified to be President. So I'm not sure that sort of changes the legal analysis about whether or not a state official can keep someone who's manifestly and admittedly unqualified off the ballot.
So it doesn't matter that the California Code, Elections Code, states very clearly that the Secretary of State shall place the name of a candidate upon the Peace and Freedom Party presidential preferential ballot and so on. You're saying that despite that language or any other codified law, statute, or anything like that, the Secretary of State's discretion is enough. What's the authority? Just the discretion is enough?
Right. So the authority is, first of all, so in Keyes versus Bowen, a case that plaintiffs have cited today, and we've cited in our briefs, the court made clear that under the provision, it's actually the Democratic primary provision, but it's identical to the peace and freedom, that the Secretary actually does maintain some discretion to exclude people from primary ballots, but not from the general election ballots. And although it's not really explained why that's the case, and this is beyond the scope of the briefing, but I will answer it, under California, sort of the California Supreme Court's interpretation of shall is not always mandatory. Shall is construed by looking at the statutory scheme as a whole. And where the statutory scheme calls for an exercise of discretion, which it does here, for example, even to determine whether a candidate is generally recognized calls for an exercise of discretion. Shall is not construed to be mandatory and still allows for an exercise of discretion by an official. And I'm happy to cite some cases if you would like them.
So the Secretary of State sounds like has been confronted with similar types of issues. I guess the residency requirement, are those similar to the age requirement?
No, they're not, Your Honor, because what happens in cases about residency requirements or asking for additional proof of citizenship, for example, in Arizona, is what's being litigated is the burden that those laws place, the constitutionality of those laws. Here, the U.S. Constitution says you have to be 35 years old to be President of the United States. That's the law. We're not revisiting that. The Secretary of State has not added a qualification to what one has to be to exercise a right to vote or to be President. She's merely reading the U.S. Constitution and enforcing it.
Does the record show, how does the Secretary of State know how old Ms. Lindsay is?
It's not alleged in the complaint, but the way the Secretary of State knows is that in doing the investigation to find out whether or not Ms. Lindsay is generally recognized, which means things like, does she have a campaign office in California? Is she on the ballot of any other state? Does she qualify for federal matching funds? It became clear that Ms. Lindsay was 27 years old. The Secretary of State is required to publish a preliminary list, which she did on February 6, 2012. It did not have Ms. Lindsay's name in it. Ms. Lindsay's counsel wrote a letter to the Secretary of State demanding that she be put on the ballot. And in that letter, which is part of the supplemental excerpts of record, and it was judicially noticed by the court, her counsel admits that she is 27 years old. So when she was excluded from the ballot, there was absolutely no dispute that Ms. Lindsay was 27. The sole argument is whether the Secretary of State can exclude someone who is admittedly and undisputedly unqualified from the ballot.
Do you dispute whether this is moot?
The court found that it was not moot because it falls into the repetition evading review.
Do you agree with that?
I understand why it would lend itself to repetition evading review, but this gets to another point, which is that plaintiffs did not actually bring an action for violation of the Elections Code, which is very much what they're suggesting here. And to do that, the Election Code specifies you bring a writ of mandate. And you have a specified time to do that. So I don't actually think plaintiffs can ever bring the kind of claim that they're bringing here. And the second point would be that by the time they moved for a preliminary injunction, the Secretary had already distributed the certified list to the 58 county officials who print the ballot. At that point, by code, she can't touch the ballot anymore. She can't add and cannot subtract names to it. So it was already too late by the time they brought their action for them to get the relief that they were seeking from the Secretary.
Could I go back to your state authority issue? What is the specific statute that you're relying on? Is it the Election Code 6720?
I'm sorry, the specific authority for generally
for deleting her name, for not allowing her name to be on the ballot.
Well, the code at issue is 6720.
Yeah. And you're relying on the discretion that goes with determining whether she's generally advocated and so forth.
Yes, as well as looking at the Elections Code as a whole and the Government Code, which gives the Secretary of State significant power and authority to regulate.
But there's no other state statute that you're relying upon?
No.
Very well. Thank
Just briefly, in the 30 seconds that I have left, I want to explain that it was not actually the Secretary's position in Robinson that she had no authority to exclude an admittedly unqualified candidate. And just to be very, very clear, although it was undisputed that Senator McCain was born in Panama, the meaning of that was very much in dispute and required interpretation. Because he was born in the Panama Canal Zone in 1936 to two American-born parents, there was some question about whether or not he qualified as an American citizen. That obviously is a legal determination that was going to be made by someone other than the Secretary. But that case it would require investigation and interpretation. That's not the case here. Finally, I would just repeat that because the complaint is nothing more than boilerplate legal conclusions, and because all of these claims have to fail as a matter of law, I would just ask that this Court affirm the district court. Thank you.
Okay, thank you. You're out of time. If you'd like to take a minute for rebuttal, you can take it.
Just briefly, I know of no state or federal court that has ever authorized the Secretary of State to interpret or enforce a qualifications provision of the United States Constitution for the office of the presidency or for Congress. That's a novel case that is presented here. In Storer v. Brown, the question was whether or not the disaffiliation provision could be utilized in terms of which party you could be associated with. So that provision has never been interpreted to be expanded past that to the actual
What happened with Elders Cleaver?
I'm sorry, Your Honor?
What happened with Elders Cleaver?
The cases were all ended up unpublished. Mr. Cleaver ended up still running but not being on the ballot. He was 34. He actually would have been 35 within the time of presidential election period, and the issue was left unresolved. When it was approached to the
But there were decisions, right? They were just not published.
Yes, Your Honor. I don't know I just know that there was a denial of the petition for cert. Beyond that, I don't know of what happened. I haven't found the underlying records.
Okay, thank you.
Thank you.
Case decided. It will stand submitted.
The only people who don't want to disclose the truth are people with something to hide.